My Lord,
Yes.
may I seek your Lordship
Yes.
indulgence in mentioning Part 2, Item number 1, hearing
Part
list.
2, item number 1.
Yes, my Lord.
Okay.
The counsel for respondent number 5, Mr. Priyanshu Goswami, is feeling unwell, so he's not able to come to Aizawl. He has requested me to pray this matter may be fixed on October 16th.
October 16th.
Yes, my Lord.
Okay. At the request made on behalf of the counsel for the respondent number 5, let this matter be listed on 16th of October
Yes, my Lord.
2025 in the part 2 list. In the hearing list, you call it a hearing list, in the hearing list. Yes.
Judge, item 3, part 2.
Okay.
If this matter can be taken up tomorrow,
All right.
I'm on that.
Okay.
Judge, the rest of them.
Take it up.
Seek your Lordship's indulgence in mentioning item number 14 of part 2.
14.
Yes.
Yes.
Counsel for the appellant, we have taken the consent of the opposite party as well. If this matter may be taken up after the vacation, Lordship.
After the vacation. You are appearing for
The appellant,
the appellant.
yes, Lordship.
Okay. At the request made on behalf of the made by the Learned Counsel for the appellant, let this matter be listed on the next part 2 hearing list after the puja vacation. Yes. Done. After the vacations. You wanted after the vacations, right? Yes.
If I may make mention, part 2,
Huh?
item 11.
11.
Yes, my lords.
Yes.
This may be taken up on Thursday subject to convenience of the court, my lords.
All right.
And my lords, item 10,
10.
this, if your lordships has it today, my lords. I've informed the other side.
All right. We'll try to upgrade it.
Great.
May I
Yes.
seek your Lordship mentioning item part 2, item number 2. My
Item
Lord,
number
with the consent of the other party, hearing may be conducted by tomorrow.
Tomorrow.
Yes, my
All
Lord.
right. Keep it for tomorrow. Yes.
Yes, item number 16, part 2.
16 years.
16, yes. The matter may be taken up after a week.
You are appearing for
Appellant.
appellant.
Yes.
At the request made by the Learned Counsel for the appellant, let this matter be listed after a week in the hearing list.
Daily list for motion, item 1.
Yes.
May I please your Lordship? My Lord, we have filed this contempt petition against the respondent's contemptor for willful disobedience of the judgment and order passed by the Honorable Division Bench of this court. If your Lordship may kindly come to page 79 and 80 of my petition. That is
Yes.
the direction passed by the Honorable Division Bench of this court.
Anyone appearing for the NPCC here? Any standing counsel for them?
There are standing counsel, but they are not here today.
You have a system of giving the advance copies to the standing counsels, no? Huh? No, I found some undertaking here that they undertake to give a extra copy this. Container numbers 1 to 5. All right. We'll issue notice at this stage,
My Lord,
but you are Mr.
Cyril Fangzola.
Okay, appearing for the applicants. This contempt petition has been filed alleging willful and deliberate non-compliance of the judgment and order dated 17/2/2025 passed by the division bench of this court in writ appeal number 11 of 2024. Stop. The aforesaid order had required the NPCC to deposit the compensation amount awarded by the award number 1 of 2018 along with interest thereon to the government of Mizoram within a period of 3 months from 17/2/2025. The state of Mizoram was thereafter required to release the compensation to the appellants as per their entitlement within a month of receiving the amount from the National Projects Construction Corporation Limited. It appears that the first communication, it appears that although the NPCC had made some communication with the Ministry of Home Affairs, nothing has been further done by the respondents for compliance of the orders of the court. Issue notice to the respondents. Full stop. Applicant to take steps by usual process as well as by registered AD within a period of 2 weeks, 1 week from today. Do you serve copies to the Standing Council?
We have to serve by registered post, my lord.
You to go by registered post, yes. List after 4 weeks with service report. That will do.
Obliged.
Item 2.
Yes.
My Lord, the present petition, criminal petition is filed under 528 of BNSS for modifications of the condition requiring submission of identity proof by the Learned Judge Special Court Sentient Pest Act. The petitioner has been granted bail under bail application number 430 of 2024, subject to certain conditions. The petitioner must respectfully seek limited conditions, modifications of the said order, specifically the condition requiring submissions of the identity of proof, a PIC or other card or driving license, on the ground that the petitioner is a refugee from Myanmar who temporarily staying in Mizoram, and as such, as he is not a citizen of India, he is ineligible to possess such required documents under the law.
Yes, anybody appearing for the PP? Additional PP? Yes?
He's a refugee, my lord, no doubt. But, my lord, steps have been taken that some ID are provided for the refugees.
Can you go through one thing, just for both of you? This is sort of something that we have been doing in the principal bench. When a non-citizen or a foreigner is detected, and he's so declared by the Foreigners Tribunal and he approaches the High Court, this is the kind of bail we grant to him if we find it up. I don't know whether she has a copy. Give her a copy. The other bail conditions remaining the same. If you see the manner in which the identity of the some of his details are taken down. Now, if there is a refugee here who's identified as a refugee and not as a citizen of India, he must have gone through some of this process to continue to stay, is it not? So now that you are saying that he has some identity as a identity proof as a refugee or something, can we modify this part? Otherwise, you are not challenging the other conditions of the bail. She is not paying for any other modification. Only the identity proof. So what kind of proof do they have here actually? There in Assam we do this with the people from Bangladesh who enter illegally and are declared so.
In this order, I have seen that they have.
We are not interfering with the amount of the surety, nothing else. How to prove the identity is the only aspect.
My lord, steps have been taken
already.
As of now, my lord, yes.
So
steps
now,
are being taken.
So now, if we say that the appropriate authority who issues the identity card, if that identity card is produced, I think it would be enough.
That will be good enough.
So you'll have to give me who's the proper authority to do that. Who keeps that record? Because this is what we do with the declared foreigners.
Yes.
We have a special, superintendent of police border who looks into these issues, keeps track of them. Here there must be some authority who will issue their identity card or who is keeping a track of these people. We will fix it on Wednesday.
Yes, my lord. Let it be.
Can it be on Wednesday, ma'am? It's okay.
Yes, my lord.
Or can you get it by tomorrow? Personal liberty of some person.
Tomorrow also, my lord. No problem.
Tomorrow. So tomorrow, once we know the authority, we'll do it. You also go through it if that can be done.
Yes, my lord.
Tell me tomorrow. This is at the request of the learned. You are the APP, ma'am?
PP.
You are the PP. Okay. At the request of the learned PP, list this matter again tomorrow for further consideration.
Item 3.
Yes.
Please, Your Worship. These writ petitions are seeking direction to the respondents number 1 and 2 to appoint an arbitrator,
Yes.
a substitute arbitrator, to adjudicate the applications filed by the petitioners before
The earlier arbitrator has recused
Withdrawn.
himself.
Yes, has
He has
withdrawn.
recused himself. Yes, anybody appearing for the railways? For the railways you are appearing?
Yes.
I have to obtain instruction. I do not have a knowledge about.
See, the arbitration is not being objected to by either by you or by them. Only difficulty is you have to appoint a substitute arbitrator, another arbitrator. So can you have the instructions within the week or you require notice on this?
Why not that notice be issued then?
A notice be issued. I think once there was already an award, right?
There was an award.
There was an award.
We
and
challenged it under Section 34 before the district court. Matter was remanded.
remanded back, and now the arbitrator
he
says that I am
recused
not doing it. So I think the railways should. Anyway, heard Mr. So-and-so, and the council paying for the petitioners. This is an application under Article 226 of the Constitution of India. Wherein the petitioners have expressed a grievance that the respondents number 1 and 2, that is the railway authorities, have failed in appointing a substitute arbitrator as required under the rules and other provisions of law after the first arbitrator had recused himself from conducting the proceedings when the matter was remanded back on an appeal having been made to the award passed by him. Full stop. Issue notice returnable in 4 weeks. Ms. So-and-so appears for the respondent number
Respondent number 1 and 2.
1 and 2. Extra copies be supplied within a period. Anybody appears for respondent number 3, Deputy Commissioner? You are appearing? Ms. So-and-so appears for respondent number 3.
Your Worship, is it required to issue notice to 4?
And not at this stage,
Not
I
at
don't
this
think so. If they appoint someone else,
Yes.
issuance of notice to respondent number 4 at this stage is not required. Since the other respondents are represented, formal steps are dispensed with. However, extra copies of the writ petition be supplied to the Standing Council Railways and the Government Advocate Mizoram within a period of 3 working days. List the matter after 4 weeks, by which time the respondent number 1 and 2 shall bring on record their response to the claims made in the writ petition. Should I fix a date?
If possible, yeah.
List on the date after 4 weeks.
21st of October.
21st of October.
I'm on. Lordship, a similar order in item 4 and 5 also.
Yes. The award number is the same?
Everything is same.
Everything is the same.
Except the arbitration case numbers are different.
Please give it on a piece of paper to him.
Yes.
As item number 4, 5 and item number 6. What changes are required to be done?
Okay.
Yes.
For admission, item number 6.
That is item number 5 you were saying, sir. Item 4 and 5. 4 and 5. 6. Yes, who's appearing 6.
In item number 6, I am for the respondent construction agency.
Hmm.
My lord, kindly come to the petition.
Yes.
The cause title of the petition. Petition is
Just a minute.
the area, my lord.
After some time.
Sorry, in this matter, senior advocate is on leg. Your Worship, he requested me to seek time for filing a reply. We have just received the affidavit filed by them.
I also have to file an additional affidavit because something other things have surfaced.
Your additional affidavit would be the second additional affidavit, or is it the first additional
the first
affidavit?
additional affidavit. We had already filed an opposition. Well, what I'd like to point out, Lordship will kindly come to page number 7.
Page number?
7, where is the petitioners are named, my lord.
Yes.
There are 2 areas mentioned. Malsuri, Lordship will find it at the bottom. There is an area, residence of Malsuri.
Malsuri, yes.
Yes. So from 58 to the last petition that is, it ends at page 13.
Yes.
119.
Other
Malsuri.
Malsuri, yes.
So my contention is that we have checked our records. No such construction has taken place at Malsuri. Because it falls within the regulated area of 1.5 kilometers. We cannot construct any board of fencing.
Have you taken the stand in the affidavit?
Yes, this I am bringing.
You have. You will bring on record.
Bringing an additional affidavit.
Mr. D. Gogoi, Learned Counsel, appearing for the respondent number.
My lords, I am for 5, 6 and 7.
For respondent number 5, 6 and 7 submits that. Did you file any other affidavit in opposition?
There is one file.
Huh?
We have filed one. Affidavit in opposition. It's there.
Okay.
Should be there.
That although an affidavit in opposition had been filed on behalf of the respondent number 5, 6 and 7 on 6th December 2024, the respondents have come to know of some other developments which he desires to bring on record by filing an additional affidavit. When can you file it?
I can file it by a month, 4 weeks.
He therefore requires, he therefore prays for 4 weeks time to bring on record the additional affidavit. Full stop. The prayer meet is allowed. The affidavit shall be, the affidavit proposed by the respondent number 5, 6 and 7 shall be filed by, give me a date.
21st.
Because thereafter I'll give them 2 weeks to file their reply. You make it 3 weeks, Mr. Gogoi. Make it 3 weeks.
3 weeks.
So that they can have 2 weeks to file their reply and we can have a date fixed. 22nd of October?
My lord.
By 22nd of October, by supplying an advance copy to all the counsels appearing for the parties in the case, full stop. The petitioners shall be at liberty to file their response to the affidavit in oppositions already on record, as well as to the additional affidavit proposed to be filed by the respondent number 5, 6 and 7 within a further period of 2 weeks. 22nd, I don't know how to do this. Then list the matter on 7th of November 2025 for further consideration.
Item 7.
Your Worship, item 7, this can come up tomorrow.
Tomorrow.
I have a personal difficulty.
We need to pass an order?
Order will be
At the request of the counsel for the petitioner, let this matter be listed tomorrow.
I'm on that.
Item 8.
You will record all the presence of all the counsels who come. Item 8. Yes, sir.
My Lord, I am for respondent number 1 and 5.
Yes.
I'll be filing my affidavit today, my Lord.
And
You
Your
are-
Worship, I'm on behalf of the government advocate, Miss Caroline.
Yes.
And she is on leave, but however, she informed me that the state will not have any affidavit in this matter.
You do not propose to file any affidavit.
Yes, as per her
And you are
instruction.
appealing for?
I'm for respondent number 1 and 5.
Respondent number 1 and 5, the
I
Lord
will be
Counsel,
filing today.
appealing for the respondents number 1 and 5 submit that the affidavit on their behalf would be filed during the course of the day. Stop. The counsel appealing for the state of Mizoram submits that they would not be filing any return in the matter. Accordingly, list this matter. When do you want it, sir?
After the vacation?
After the vacation. List the matter after the vacations, by which time the petitioners may file their reply. Yes?
After the vacation.
By which time the petitioners may also file their reply to the
Obliged.
counter affidavit. Yes.
Item 9.
Please, Your Lordship. Your Lordship, here in this matter, I represent respondent number 13, 14 and 15. Sorry, 14, 15 and 16.
Yes.
And from the information that I have received, there is some development in the matter.
What development?
May I produce this letter, Your Lordship? This is with regards to...
Who is appearing for the deputy commissioner?
I am, Your Lordship.
You are appearing.
Yes.
Now you are just required to
Make the
dispose
assessment.
of the representation.
No, my lord.
What was the order? Yes, madam, what was the order? What is the order which you are complaining contempt of?
My Lord, the order dated 17/3/2022.
Yes.
Annexion number 1, page number
What is the
3.
direction?
Yes, the direction is the court has directed the respondent number 12 to verify my claim in terms of the representation, and thereafter, if
After?
my claim is found to be, if I am found to be entitled to pay interest for delayed payment of compensation, the respondent number 12 shall make calculations within a period of 4 weeks from the date of receipt of certified copy of this order.
Yes.
After making such calculations, the respondent number 12 shall forward.
But have you disposed of the representation dated 19/8/2021?
Yes, Your Lordship, I have already filed my show cause reply affidavit in
Yes.
this regard also. That is
Respondent number 13.
Oh, 21 March 2023.
21 March. Is it on record? 11/9/2024. Yes. Yes, what have you said?
Yes. So what we have stated in this letter is that we have received a letter from the Assistant EE Mort, Government of India, with a request to instructions, and thereon with the copy of the order. And then accordingly, we have made the assessment, Your Lordship, to cut the matter short, which I have annexed in my affidavit. Your Lordship, if I may come straight to paragraph number 7.
Yes.
6 we have stated that we have made the assessment. 7, review of calculation of interest. This is as per the section 34 interest. So later on, after filing of this affidavit, there was a development with a request from the acquiring authority to make the date of possession clear. So the date of possession was made clear. Now with the documents that I have submitted today, there is a revised estimate calculation that was sent by the SE to the regional officer, Ministry of Road and Transport Highways on 14 February 2025.
Okay. Thereafter, nothing has happened.
Nothing has happened.
Yes,
We are
so
waiting for the
what is that respondent number?
My Lord, I'm for respondent number 2. I have filed my so-called reply on 11/9/2024.
24, no, you had a letter on 14th
Yes, my
of
Lord.
February 2025.
After filing my affidavit, I have to obtain instruction. I just know about the letter today, my Lord.
It is you who knows about the letter to the contemptor must have known about it quite a long time back.
My Lord, as on filing my affidavit, that is 11/9/2024.
Contempt matters, madam, we are a bit...
My Lord, we just have a knowledge about the letter today, my Lord.
From my side,
from my side, my Lord.
This affidavit was filed on 4th of July 2025. This affidavit by
My
the...
affidavit.
Did you serve her a copy? You got a copy of the affidavit filed by the respondent number 13? Have you served a copy of the...
Yes. Unless we serve, we cannot file, we can go through the registry.
Then, see, contempt matters where orders of the courts are being taken lightly by any of the respondents.
My Lord, at the time of filing affidavit by the state,
Yes.
they didn't say about the interest, the conflicting interest, date of possession. However,
we are fixing
now
this-
there is a new development.
We are fixing this matter on Thursday. Today is Monday, we are fixing it on Thursday.
Yes, my Lord.
Kindly have your instructions what has happened after
Yes.
this letter of
Yes, my
14th
Lord.
of February 2025.
Yes, my Lord.
In case he has any difficulty in giving you instructions, kindly advise him. We will have him here on Friday.
Yes, my Lord.
Orders of the court will not be taken lightly.
Yes,
Either they work on it, tell me how and why they cannot comply with the order. But sleeping over the matter, we will not entertain. List this matter on, we'll fix it on, 25th. No, make it 24th, so that we can have him on 25th if we don't have anything. List this matter again on 24th of September 2025 to enable Ms. So-and-so to have her instructions, updated instructions with regard to the steps taken by the respondent number. You are appearing for respondent number? You are appearing for respondent number, madam?
My Lord, I'm for respondent number 2.
Respondent number 2. Respondent number 2 regarding compliance of the orders passed by this court. It is made clear that in the absence of instructions, adverse orders may follow. Yes.
Item 10. Item number 10.
Please, Your Lordship,
Yes.
this is also a contempt matter for non-compliance of the order dated 15/5/2023.
Yes.
The order, Your Lordship, it's at page 20. It is regarding acquisition of land and for payment of interest under Section 28 of the Land Acquisition Act, Your Lordship. The effective portion is at page 31, Your Lordship. So it's a simple order directing for payment of interest, and it was since it is a covered matter, Your Lordship. Similar landowners from the same award, from the same village, they have been paid the interest under Section 28. So we have come saying we are also to be paid the same interest since everything is similar from the same village, from the same award, same acquisition. and this court has passed order that yes, this is a cover matter, you should also pay.
Has the district collector Kolasib examined the claim?
Examine the claim, and Your Lordship, on the next page, at page 33, Your Lordship will see, page 33, if Your Lordship have it.
Yes.
Yes, page 33, Your Lordship. This is the order of examination. If I may kindly read, Your Lordship.
It's okay. No person to the other institution assignment of interest. Yes. This was written to the General Manager Construction in 2023. Why is the matter pending for so long in a contempt
Yes, Your Lordship. So it was verified that it is a similar matter and they are genuine landowners and they should be paid. And calculation of the interest was also made by, as directed by this court. And this calculation with the order was sent to the respondents for making payment. And Your Lordship, the railway authorities did not object to the assessment calculation of interest. The only thing is that they have submitted a letter to the district collector saying that certain corrections should be made, and we will pay. So that letter was here at Annexure 4 only. So that correction, as per the request of the railway authorities, correction was made by the district collector. Still, that payment has not been made.
Okay. Who appears for the railway authorities? Mr. Gupta, you appear? It's become still. Yes, Mr. Gupta. Are you appearing in the matter?
My lord, I am. Yes, my lord.
Yes.
Yes, my lord. For 1 to 7, we have already filed affidavit. And my lord, in fact, in relation to this matter, the issue
I think you'll have to move to a better place.
is pending before the division bench. My lord, here the issue is, my lord, whether
Network here is bad or there is bad? Mr. Gupta,
my lord,
you have to move to a better place.
my lord,
I am getting you in bits and pieces.
my lord,
You can't conduct it like this. Go to some better network place. We'll take this matter up after 10 minutes.
my lord.
End of the list. Okay. Have some place with some better
my
network.
lord, my lord,
We are not happy
lord.
with the reply file.
my lord.
Let's call it at the end of the list.
Item
My
11.
Item 10. No, 11. Yes, item 11.
Yes, Your Lordship, I'm for the state respondent,
Yes.
and I'm seeking another 3 weeks' time, Your Lordship, to file my affidavit.
Why? I thought the counsel for the petitioner
I have no objection in
would have
this
been taking
respect,
time.
and
You were required to file you are for the
No, I have to
respond-
file my affidavit in opposition, and I'm seeking 3 weeks' time. I'm the respondent,
Ms.
Your Lordship.
So-and-so, Learned Counsel appearing for the petitioner also. Just a minute, I'm not dictating the order. Just a minute. Affidavit in opposition has already been submitted on behalf of respondent number 4. You are appearing for?
I'm for respondent.
4. You are appearing for?
I'm appearing for the state government, Your Lordship.
State.
1, 2,
Respondent
3,
number
5
1
and
to
6.
3, 5 and 6.
Okay, you take down the attendance. And you are filing, have you filed your reply?
Not yet, my lord. I'm seeking for filing the rejoinder affidavit against the respondent number 4 affidavit.
Your bank accounts are freezed and you are not taking, don't need the money. Okay, Ms. So-and-so, appearing for the respondent's number so-and-so has made a request that she be allowed another
3 weeks' time, Your
3
Lordship.
weeks' time to file the affidavit in opposition in response to the writ petition. Ms. So-and-so appearing for the petitioner also prays for some time to file her affidavit in reply to the affidavit in opposition filed by the respondent number 4. Sixth week कितना होता है? On the 6th week from today. Third of November. List this matter on the 4th of November, by which time the respondents so and so shall ensure filing of their response to the writ petition and the petitioner in the meantime may also file their replies to the affidavits already on record and also to any affidavit filed in the meantime.
My lord, my presence may be kindly reflected.
Yes, record presence of everybody.
Obliged.
Since I am not conversant with the names here, I am making a request to him to make to mark the presence. Yes.
Item 12.
12. Yes.
With due respect, Your Lordship, here in this matter, we
Yes.
have already filed the affidavit in
You are for respondent number 4?
number 4, yes.
Number 4. And what about the other respondents?
My lord, so far only notice was issued to respondent number 4.
Respondent number 4 has appeared now and filed her response. What do you say?
My lord, only upon the respondent number 4 notice has been issued at this stage.
Yes.
And in the affidavit, my lord, what they have said is that they have to make some correction in the reassessment.
Yes.
Which they are yet to done.
Your Lordship, we
Yes,
are-
what is taking so much of time, madam?
Your
This is-
Lordship, we are waiting for the response from the BRTF as of date.
BRTF was not a
Your
party in the
Lordship,
petition?
Yes.
They
Your
are a
Lordship,
party, they are a party. Notice has not been issued yet to the BRTF officials.
It has to come from the
But my
BRTF.
lord, the direction of this court is that the district collector shall prepare fresh award in terms of the 2013 Act. And it is the respondent number 4 who has to prepare that award.
We did, Your Lordship, if I may take Your Lordship kind attention to page number 3, paragraph number 5 of my affidavit. Here we have made an assessment. And calculation error was made in paragraph number 6. And this accordingly this office rectified the said or error and submitted the corrected award to the government of Mizoram for approval. So after that, we have the government have directed for a fresh reassessment in paragraph number 8.
Okay.
And then, however, no response has been received from the BRTF till date in page number 5.
Yes, take down.
So that is the.
Mr. So-and-so appears for the petitioners. Ms. So-and-so appears for the respondent number 5.
4.
4. For the respondent number 4, full stop. By the order dated 20th of May 2024, this court had directed
Para 7.
the respondent number 4 to issue a fresh award in terms of the 2013 Act for assessing the compensation to be paid to the writ petitioners. Full stop. The entire exercise of payment of compensation to the petitioners after adjustment of any compensation already paid was required to be completed within a period of 5 months from the date of receipt of a certified copy of the order by the respondents. Ms. So-and-so appearing for the respondent number 4 has submitted that in compliance of the orders, a calculation had been made and submitted to the government of Mizoram, where the government had also conveyed its approval on 28/10/2025 when the matter was referred to the acquiring authority. When the matter was thereafter informed to the BRTF, a calculation error was pointed out and a request for carrying out the necessary corrections was made. Full stop. The counsel for the respondent number 4 says submits that the said error has been rectified and the corrected award was resubmitted to the government of Mizoram for approval. Stop. The government of Mizoram had thereafter, the respondent number 4, who did it? The respondent number 4 had thereafter requested the BRTF on 9/5/2025, informing them the necessity for making the reassessment, which would result in an increased compensation amount. It is submitted that the respondent number 4 has not received any response from the BRTF till date. Yes, who's the competent officer in the BRTF?
My lord, respondent number 2. Notice may be issued upon them.
Just a minute.
1, 2, and 3.
Just a minute. When was the notice issued on respondent number 4?
The first notice was issued on 11 March 2025.
By order dated 11/3/2025, notice was issued only to the respondent number 4. Full stop. From the stand taken by the respondent number 4 in the affidavit, it appears that the presence of the other respondents would be necessary. Other respondents would be necessary to determine the stage where the order of this court is now awaiting compliance. Full stop. In view of the above, issue notice to the respondents number 1, 2, and 3. Stop. The Honorable Counsel for the petitioner is directed to take steps for service upon the respondents by way of registered post with AD within 2 working days from today. List a matter after 4 weeks on a date to be fixed by registry along with the service report.
Item 13.
Another complaint. Okay. Yes.
My lord, in item 13, I am appearing for the sole respondent. I have filed my show cause reply, wherein we have stated that the order of this honorable court has been complied.
Yes.
My lord, it has been complied, and so at this stage, my lord, the matter can be disposed because the state respondents have complied as per the order. They have reconsidered the claim of the petitioner, but that was rejected, unfortunately.
Okay, heard Mr. So-and-so and Ms. So-and-so. Heard Mr. So-and-so appearing for the petitioner and Ms. So-and-so appearing for the sole respondent. The allegation in this contempt petition was regarding the deliberate and willful non-compliance of the order dated 1/5/2005 passed by this court in WPC in W. It's a criminal matter.
WP criminal.
WP criminal.
It was WP criminal.
Yes, ma'am.
But you were asking for service benefits.
My lord, initially, may I explain, my lord? WP criminal number 2 of 2024.
Yes.
Was filed by the petitioner himself.
From jail.
From jail. And I was appointed as a legal aid counsel.
I understand. No, but that is what I am trying to understand. Why is a WP criminal when they are asking for service matters? Just because it is from the jail. Subject matter has to determine the nomenclature. Yes, in WP criminal 2 of 2024, by which the sole respondent was required to consider the claim of the petitioner for encashment of unutilized earned leave and also to pass a necessary order considering the case of the petitioner for grant of compassionate allowance in terms of the observations made in the order dated 1/5/2005. Full stop. Today, a submission from the affidavit in opposition, from the show cause reply filed by the sole respondent, it appears that the claim, that the order dated 1/5/2025 passed by this court has been complied by the sole respondent by passing an order bearing memo number, you will find it page number 7 down below. Okay, I've given A to A. Dated 1st of July 2025, the learned legal aid counsel appearing for the petitioner has also submitted that the said order is in compliance of the orders passed by this court. In such view of the matter, this contempt petition does not require any further adjudication and is accordingly closed on compliance. Stop. The petitioner shall, however, be at liberty to assail the order dated 1st of July 2025 if so advised. Contempt case disposed. Yes.
For orders, item 14.
Oh, item 10, yes, is he on record? Yes, Mr. Gupta.
No, in item 10, my lord, one thing I was going through, my lord, the respondent number 7 is newly implemented. Now he is no more, my lord. Hitesh Jaiswal. So, my lord, he is the main person, the deputy chief engineer. If my learned friend can.
You are appearing for respondent number?
I am appearing for all the respondents, my lord. On the
All
last
the respondents.
occasion.
Now, Mr. Gupta will kindly tell us. How does the pendency of some other of an issue in some other writ appeal absolve you of the duty to either comply with this order or to take whatever steps you deem fit?
Because, my lord, the issue is similar, my lord. There are many writ petitions which have been disposed of.
You tell us, have you preferred a review or an appeal on this?
Yes, my lord. We have
On this
already
writ
prepared.
petition? On this order?
Yes. That is, but that has not come up, my lord, for listing.
When was
the
it
appeal
filed?
has already been filed. I will, my lord, the number, my lord.
When is been filed? Your affidavit was filed when? You are appearing for respondent number?
My lord, all the respondents, my lord, the affidavit filed on behalf of 4. Respondent number 4, it is filed, already filed.
7 has also filed something.
No, my lord, 7 is wrongly, my lord, mentioned that I was.
Yes, you were
corrected-
required to correct it. You did not correct it also.
My lord, that, my lord, I was supposed to travel, my lord, physically, but I could not travel last week itself. My lord, that I will correct next, my lord, in the first week of the October, my lord.
Yes, you say that you had filed an appeal against this order also. Can you give us the filing number?
Yes, my lord. My lord, WA number 6 of 2025.
You make a
Along
note
with-
of this. Yes?
Along with IA Civil 54 of 25.
How many days
wherein
delay?
Notice has been already issued. And
How
the
many
parties
days
have-
delay?
Condoned, my lord, delay condoned.
No, it's not been listed, it's not been admitted.
You said it is not listed. How?
My lord, we have taken steps on the IA by paper publication. The council have appeared in the IA and they have paid time to file objection.
Notice has been issued. We have been directed to appear. That's it. The IA has not been touched upon.
IA has not been
That's a
discussed.
condemnation of delay of more than around 3 years. This is 2003 judgment. So almost
2023 judgment?
2023 judgment. Sorry.
Yes, then kindly tell us what you did from 2023 to 2025. Just because a contempt is pending and now you rush with the IA doesn't absolve you of what you had done in the interregnum. Is it not?
Yes, my lord.
What did you do from the date you received this order till now is what we want to know.
My lord, the order is of 27/7/23.
Yes. And what was done in the meantime is what we want to know. If this affidavit does not explain.
My lord.
And my lord, one more thing is that
My lord, will take annexure.
in the other matters, from the same they have paid. They have made payment in similar matters from the same village. They have paid. My neighbors have got their money. They have interest. The same thing.
Interest under
It is,
both the
it is
provisions,
only
my
that
lord.
why are they delaying me? I don't know. They have certain interest in other petitions. I don't know, but that is
My
why
lord,
this
paid,
order was
but
passed.
Yes, we'll come back to you. Yes, Mr. Gupta, tell us what you did from 2023 to 2025 till the date of preferring the appeal.
My lord, we have filed affidavit, my lord, explaining, my lord, what we have done.
Yes.
And my lord, it is only
us.
after the order passed by the division bench, my lord, that interest under both the section cannot be granted. There was a stay, my lord. That's why the authorities are now, my lord, not proceeding further.
When did the stay come?
My lord, it came on 6/9/24, my lord.
What happened from 2023 to 6/9/2024?
My lord, prior to that, my lord, at page 21, my lord, will take
page?
The order, page 21, annexure 1. My lord,
Yes.
the writ petition was preferred, my lord, WPC 68 of 2023, where, my lord, we have raised the issue that payments under both section 28 and 34.
Is that the order of this court, order in this case also?
Yes,
the order in the
here
case is
also-
not similar.
Here also, my lord, the petitioner have got the interest under one of the section, my lord, but they have suppressed this fact before the single bench. That I have stated in my lord, the reply also. They have got the interest under one provision, but they have intentionally filed two writ petitions claiming interest under two different sections which they are not entitled to.
If I may, Your Lordship.
My lord, here my lord, paragraph 7 of my reply, I have stated, my lord, that they have already been assessed for payment under section 34. However, the said fact was suppressed by the petitioners, and they have filed another.
See,
petition.
all those things you could have taken up in a writ appeal filed in appropriate time. You could have filed for a review within the appropriate
similar
time.
matter we have taken. That is what I was pointing
Then
out.
all these similar matters where you then all these similar matters where you try to take up that you file an appeal, all the other similar matters have to go under a stay. Whatever is similar, all the contempts go. Cannot be. So what to do? We wait for the disposal of the appeal.
My lord, one thing is that before that, Your Lordship, my learned friend is mixed up with some other matters. Maybe he's taking up so many matters. We in this contempt matter.
I saw the order. The order was only to consider your claim under section 28.
And
34 was
in
not
his
given.
affidavit, we have stated that we have received under 34. We have not received a single penny, Your Lordship. So
Then
he has made the mix-up with other
You
cases.
do one thing. What I'll tell you is this. He has stated in his affidavit that you have already received it under 34.
34.
No. We have
He has made a statement in the affidavit. You bring on an affidavit and have please show us where you have paid under 34. That payment.
Paragraph 7.
That
Page
payment
7.
something is there. Where is the
Page
payment?
7, paragraph 7.
No. There's a statement. There's no
No, not the statement.
payment slip has to be there. We have not. It's not there.
Page 7, paragraph 7, my lord, we have stated that although we did not get any opportunity to clarify this fact, my lord, because no affidavit in opposition was filed, my lord, it was disposed of on the first day.
No. You have made a wrong statement, Mr. Gupta. They have been assessed for payment. They have not been paid anything. Please read your affidavit.
Yes.
Have you paid under 34?
No, that I have to take instruction, my lord. But why
Yes, sir.
we have not paid, my lord, is that since they are
You have
claiming
to
under
pay
both
at
the
least
sections.
one of them, either 34 or 28. And let us have a look at the judgment, that order again. What is that order?
That issue, my lord, is pending in division bench. That is what, my lord,
You
whether
kindly come to page 31.
yes. Page 31, my lord, yes. Page 31.
When did
Yes,
the
my
district collector send it to you?
Page 31 is the appellate court order, my lord.
No. Page 31 is the... No, of the contempt petition.
Yes.
Come to the contempt petition.
Yes, ma'am.
District collector was required to examine the claim of the petitioner. Such exercise should be taken within a period of 6 weeks from the date of receipt of a certified copy of the order. Once the assessment is made, the district collector COSAP shall forward the same to the respondent, and the respondent shall make arrangement for required fund within a period of 6 weeks. Now kindly come to page 33.
Yes, ma'am.
The General Manager Construction, Chief Administrative Officer and Chief Engineer Construction, Deputy Chief Engineer have been informed.
Yes.
That was on the 1st of June 2023.
Yes, ma'am.
1st of June. So June gone, July mid, by summer vacation, the 6 weeks period was over.
Yes, ma'am.
Then you wrote a letter.
Yes, 39.
In which you refer to the WPC number 47 of 2023, correct?
Yes. My lord, here, if my lord will take the case 39 reply to that letter. The letter.
So you knew in the year 2023 that this order of this court is existing.
1st June 23, my lord, when I was communicated. After that, we replied.
You replied. So on 26th of June 2023, at least you knew that there is an order directing your payment directing you to pay within 6 weeks.
Yes, but my lord will see the contents of that letter, my lord.
Yes.
That letter says, my lord, that all the petitioners
resubmit the assessment sheet after correction calculation. Come to the last line.
Yes.
Then you come to page
40.
Page 43. The recalculation is given on 24th of July 2023.
Yes.
Yes. Now tell us. You filed an appeal in 20. That writ appeal, when did you file it? In 2024. The order on that appeal comes on September 2024. You had notice of this writ petition. You had notice of the orders of this court in this writ petition. What steps were taken?
No, my lord, since similar matters are on the same issue, my lord, there are
nothing doing. There is an order operating. The appeal will decide that issue. That decision will not ipso facto apply to the orders passed by this court in this writ petition.
But as to the entitlement of the petitioner of claiming interest under both the provisions.
The problem is you have not even paid him under 34 also.
Because of this confusion only, my lord.
There is 28 or 34. The court said you.
34.
The court said that the court said that you consider him under 28 and pass order district collector. District collector has given you something. 34 is something that you never contested before any authority. Any forum, you did not contest whatever was required to be paid to them under 34.
Yes.
Now, in the guise of this appeal, you are not only violating the orders of the court, you are also denying them the compensation under 34 also. Are you getting what we are trying to say?
We are ready to pay under one of the provisions. But, my lord, since page 29, my lord,
so even if you get a stay in your, even if the delay is condoned and you get a stay in your 28 provision under whatever was required to be done under 28, if you get a stay on that, your liability under 34 doesn't go.
Yes. My lord, therefore, I was submitting, my lord, since the matter is pending before the division bench, as to under what provisions they would be entitled to be paid interest, whether 28 or 34. And our contention is that it cannot be both the provisions. It will be either of the provisions.
Your statement in the affidavit is that they would be not entitled to be paid under two provisions.
Yes.
One provision you already agreed, 34. 34 you never challenged.
Never challenged, but at the same time,
taking the guise of this order, a challenge to this order, you are denying them of everything.
But the same set of writ petitions are claiming under 28 also.
Maybe. 34 you are not disputing. 28 you are disputing that once we pay under 34 you will not be entitled to 28.
And therefore, I am submitting the issue as to their entitlement whether under 28 or 34, that is pending adjudication
Their
before the division bench.
entitlement under 34 is never under challenge. The only entitlement you are challenging is under 28 because it has been given in addition to 34. You cannot deprive them of both.
Yes, that we
Assuming you cannot give under both, you will not deprive them of both at the same time. And you are not paying it under 34, which is not disputed.
Let there be a finding of the Honorable Division Bench on the issue as to their entitlement under what correct provision, because that issue is sub judice. If we pay under 34 and tomorrow Division Bench decides that they are entitled under 28,
you will deduct whatever was paid under 34. You will deduct whatever was paid under 34. That is the only solution.
In that case, in my opinion, even I have advised the department to pay under one section. But since there is a confusion, because the same set of petitioners are claiming under two provisions of law, knowing the fact and suppressing the fact that they are being paid.
Okay, we understood. Yes.
To simplify the matter,
yes.
If they make a payment, immediate payment under section 28, we will not press under 34. That we can submit.
No. That you have to come up with that.
The order under 34
I am agreeing with that.
was not made by the court.
Learned friend is submitting that, making that submission.
Mr. Gupta, we will not hear two counsels at the same time. We cannot. It is not we will not, it is we cannot.
Well, if I may continue.
Yes.
Yes. The claim of 34, interest under 32, is not passed by the court. It was, the petitioners went directly to the district collector, and it was the award of the district collector under 34. And that award has not been satisfied till date.
What is the method to do that?
So my lord.
What is the method to get it satisfied?
My lord,
not the contempt.
Since this is regarding 28, because it was an enhancement of compensation. So if you look at to the section 28 under the Land Acquisition Act, it says that when there's an enhancement of award, enhancement of compensation, the interest, that enhanced interest under section 28 will be applicable. So this, and in Pushpa Party versus Union of India, the Supreme Court says that it is the Supreme Court who has to pronounce section 28. So we have come under the PPC.
Okay, let us do it this way. We give them 1 week time.
Yes.
In the meantime, since you are appearing in the appeal, you try out that also. And since they brought on record that there is a writ appeal has been filed, admittedly you are appearing in that. I think propriety will demand that we do not take up coercive action immediately. This ground of your not being paid under 34 when it is not under challenge and all that, these can all be your grounds before the writ appeal. Even to the extent of challenging their, any stand that they have taken in the writ appeal.
Well, the thing is that if we go through the order of the single judge, which is the compliance of which we have been doing, it is clear that, my lord,
okay.
you will see that.
Okay, we'll take it this way. Let me pass the order. Yes, heard Mr. So-and-so. Learned counsel appearing for the petitioner. Also heard Mr. H. Gupta, learned counsel appearing for the respondent number 4. By the order dated 7/8/2025, it was noticed that the affidavit in opposition filed on behalf of respondent number 4 was wrongly nomenclatured as to have been filed by the respondent number 7, and the counsel for the respondent number 4 was required to have made necessary corrections in the cause title of the affidavit in opposition filed before the court. However, as the counsel for the respondent number 4 was not in a position to attend the court proceedings physically prior to today, the said correction has not been carried out, for which the counsel for the petitioner has submitted his apologies and prays for some further time to do the necessary correction. Prayer is allowed. He is allowed another 2 weeks, 1 week time to have the necessary corrections effectuated. Stop. Learned counsel for the petitioner has referred to the order dated 15/5/2023 to submit that the District Collector Kolasib has already examined the claim of the petitioners for payment of interest under Section 28 of the Land Acquisition Act and had forwarded the assessment so made to the respondent number 5 to 9 in the writ petition for making necessary arrangements to the respondent number. Whom did you send it to? They sent it to the respondents in the railway authorities, to the respondents in the in the NF Railway for payment of the enhanced amount. Full stop. He has also pointed out that by letter dated 26/6/2023, the Deputy CE oblique CON BHRB NF Railway had requested for certain clarifications on oblique corrections, and the office of the District Collector Kolasib District had also forwarded had clarified to the Deputy Chief Manager Bairabi NF Railway that the assessment made in respect of WPC 47 of 2023 and the assessment made.
I beg your pardon, Your Lordship.
Yes.
One point. If we see the letter 26/6/2022, Your Lordship, at point number 2, Your Lordship, you will see that they have stated that hence no claim can be given in respect of Zothapui and 81 others. That means that they are not trying to give Section 34. So they have already admitted that Section 34 we cannot give. So, and the Deputy CE has said that to make let me complete the order, then you. And so, what I'm trying to say is to simplify the matter. My learned friend has admitted, and it is the admitted position of the NF Railway that they will pay under one section. So, and they have already, the Deputy CE has written to the District Collector that they will not pay under 34.
There is a difficulty. There is a difficulty. Contempt jurisdiction binds me to see whether the order is being complied or not. I cannot go beyond that.
He admitted, my learned friends admitted that Section 28 will give. So let them pay the 28.
Let me dictate the order.
And then
let me dictate the order. Yes. What did we say last sentence, madam? And the interest under Section 34 in the case of Zothanpui and 81 others are separate cases which are under different provisions under the said LA Act. Full stop. A request was again made to deposit the total assessed amount of interest compensation in favor of Rinzwala. In favor of the petitioners, to the understand within 6 weeks from the date of receipt of the assessment for disbursal to the petitioner. Full stop. Mr. H. Gupta, appearing for the respondent number 4 in his affidavit, has referred to the affidavit filed on 21/3/2025 to inform this court that the respondents have assailed an order dated 27/7/2023 passed in WPC number 68 of 2023, wherein this court had held that wherein the court had held that the case of the writ petitioner in WPC number 68 of 2023 was not a case that a single individual has been given an assessment for the same plot of land in two places. Full stop. This court in that case had held that the provisions under section 28 and 34 of the LA Act did not that in view of the provisions under section 28 and 34 of the LA Act, there can be no question of adjustment being made from the amount awarded under section 34 of the LA Act as contended by the petitioner. Full stop. The petitioners in that case was the Union of India through the NF Railway. Mr. Gupta has drawn our attention to the orders passed in Writ Appeal 8 of 2024, wherein the division bench of this court has stayed the effect and operation of the impugned order passed by the learned single judge on 27/7/2023 in WPC number 68 of 2023. Full stop. The learned counsel appearing for the respondent number 4 has sought to emphasize that the subject matter in before the appellate court, the subject matter in the intra-court appeal, i.e. WA number 8 of 2024 is similar to that of this writ petition, which was preferred by the petitioners herein, and therefore this court may keep in abeyance the present contempt proceedings till the disposal of the writ appeal. Full stop. He has also submitted that they have preferred a writ appeal against the order dated. What was the order dated in this case? 15/5/2023, passed by this court in WPC number 47 of 2023. So on this time it is
2023.
2023. Are there two writ petitions?
The order is 23 years old.
Oh, no, okay. In WPC number 47 of 2022. And the delay in filing the writ appeal is under consideration of the division bench in IA civil number. Do you have this IA number?
Yes, my lord. IA number, my lord, 54 of 25.
54 of 25.
25.
Okay. The learned counsel for the respondent number 4 submits that. Now further informs the court on a pointed query that there is no stay order operating against the order dated 15/3/2023 passed in WPC number 47 of 2022. Stop.
No, it is 23, my lord. 23.
Huh?
W47, 23, my lord. 47 of 23. The contempt is WPC 47 of 23, my lord. Page 20 of the contempt petition.
Page
20, Annexure 1. 20.
I don't know at page your affidavit page 40. Last paragraph 47 of 2022. Therefore I was asking, are there two writ petitions? 47 of 23.
No,
Yes, sir.
This contempt is against the violation
Just a
of the
minute,
order,
Mr.
my
Gupta,
lord.
just a minute. Please call him.
47 of 25. Yes.
Please, sir, come here. Yes, you. Yes, sir, I am requesting you. Please be here. Please come here. Please come here. what was happening?
Regarding my case at the district court, my junior is.
There is a door there. There is a corridor outside.
Yes, I'm really sorry, my lord. I will never do it again.
This will not be tolerated. We'll take it up as a misconduct.
Please, my lord, pardon me. It won't happen again.
There is some decorum that we want in this court.
Yes, I'm really sorry, my lord.
I have the experience of the Guwahati High Court. There was a judgment being cited and I was sitting like you were.
Yes.
And I was trying to look up that judgment in my mobile.
Yes.
And I was required to deposit my mobile for the day. For just looking at the screen of my mobile.
Yes.
And when I was looking up the judgment, which was being referred to in the court, I was trying to find out what did the judgment actually say. You are using the phone as if. Is that not? Have you never been told in the court not to use the phone? You kindly keep a. If required, you put up those notifications that we have in the principal seat and other benches. Because the people are not aware. First, we have to make them aware of the manner in which a court has to be conducted. We sincerely hope this will not be repeated.
I'm really sorry, my lord. I won't do it again.
These are sacred premises, is it not, sir? These are sacred premises where someone is fighting for liberty, someone is fighting for something. In fact, we leave our mobile phones are not here with us. We do not know what emergency calls will come. We never care about that. And whether you are here in the court or not, this court is here till 4:30. Is it not?
Yes.
This type of things. Please do.
Thank
and
you,
I
my
hope.
lord.
Yes, where were you, man? Did you see it is for 2022 somewhere and 2023 somewhere?
Yes, my lord, it is in the deputy collector, my lord, maybe wrongly he has mentioned is at as 22, my lord. It should be 47 of 23.
Wherever we have dictated 47 of 2023 or 2022, please make it 2023, the writ petition number. Huh? So, what was the last sentence we were saying, madam? No, you have to repeat the sentence again. What did we say? Okay, there is no stay operating against the order 15-3 23 WPC no 47 of 203. On the next line you take down. We have noticed that the respondent authority in their communication dated 26/6/2023 did not raise any such ground as sought to be raised by them now, and in fact by the letter dated 24th of July 2023 they were informed by the district collector, Kolasib district, that the subject matters in the two writ petitions referred to were different and full stop. However, the respondent authorities did not take up any process after receipt of the order dated 24th of July 2023. And it is at this point of time that a submission is made that a writ appeal has been preferred. Full stop. It is also a matter of record that the although also a matter of record that although Mr. Gupta submits that the the claim of the petitioners had been assessed under section 34 of the Land Acquisition Act, the learned counsel for the petitioner has asserted that even payment of compensation under the said section, which was never in dispute in the parent writ petition, has not been made till date. Full stop. In view of all the above, this court is of the prima facie view that the respondent number 4 has attempted to take advantage of a writ appeal belatedly filed to justify the non-payment during and after the filing of the writ appeal. Full stop. He has, however, not stated as to what course of action was undertaken between the time period when the corrected and when the letter dated 26/6/2023 was received in his office. Full stop. Since a writ appeal has been preferred where the issue of delay, condonation of the delay is being considered, and the counsel for the petitioner and the petitioners in this contempt petition have also entered appearance, this court defers the present contempt petition by a period of 3 weeks. Full stop. In the meantime, the nomenclature of the respondent number 4, wrongly titled respondent number 7 in the affidavit filed on 21st of March 2025 shall be carried out by the learned counsel for the respondents. The respondent number 4 would be at liberty to file an additional affidavit explaining as to what steps were taken by him after receipt of the order dated 26/6/2023 till the date of filing of the writ appeal, along with the application for condonation of delay, in order to enable this court to assess whether the respondent number 4 had deliberately slept over the directions given by this court. Full stop. Please the matters again on. Yes, when do you want it? Mr. Gupta, when do you want it?
My Lord, after the, my Lord, this puja vacations, my Lord, or the second week of October, my Lord, we will file the additional affidavit explaining that, my Lord.
9th of October? It's good enough. Today is what? Today is 9th of October. Yes, for you. 9th is fine. 9th is fine for him. We'll fix it on 9th of October. 9th of October. Oh no, I gave you some time. We put it after 3 weeks. How can 9th of October be 3 weeks?
My Lord, my Lord.
13th. So we'll have it on 16th. Huh? 16th of October. Have the corrections done and file your additional affidavit explaining what was done prior to filing of the writ appeal.
Yes. That order is in the second last sentence, it should be order of the district court 24th July 2023, not 26/6.
24th of July 2023. Last time where I said 26/6/2023, it will be 24 July 2023. Yes. Yes.
Hearing list, item number 10.
Hearing list, item number 10. We just did it. Which one did we do? Oh, this is hearing list.
Yes.
Okay, hearing list.
My lords, before anything, my lords, I've informed, despite informing the other side on Friday and today, I've chosen not to come, my lords. So
What is the matter about?
My lords, here the issue is regarding the plaintiff had filed a suit, my lords, for declaration and for money, for recovery of money, my lords. We are saying that, my lords, I'm the appellant, the defendant in the suit. The suit was decreed in favor of the plaintiff. Two issues were there, my lords. One was whether the plaintiff was a subcontractor of the contractor defendant, the appellant today.
Whether the appellant is a subcontractor of the plaintiff.
My lords, the plaintiff, whether the plaintiff was a subcontractor of the contractor who is the defendant.
Okay.
Second issue was whether, my lords, an amount of, my lords, 50 lakhs odd was recoverable from me, the appellant, the defendant, by the plaintiff, my lords. These were the two issues.
Okay.
We are saying today, my lords, that there was no evidence adduced on record and there is no admission in our written statement. Despite that, my lord, the trial court had erringly, my lords, passed the decree against me.
Saying that you had admitted it?
No, my lord. Saying that the plaintiff had proven his case and therefore...
Where is that order?
Your lordship. Lordships, if your lordships has the paper book, the order...
Will it be difficult tomorrow?
My lords, we were hoping, my lords, I had talked to him.
No, I understand, but
yes.
Maybe he is under the impression that
yes, my lords.
We will take it up, we'll take some more time in reaching the matter.
Wednesday is convenient to your lordship.
Wednesday?
Yes, my lords. It is a day for division bench, but my lords, after division bench, if your lordships...
No difficulty. If we have time after division bench, I won't have any difficulty.
Grateful, my lords.
So, we'll take it up on Wednesday after the division bench, if time allows. Kindly inform the side that we have taken up the matter and we have only deferred it because we don't want to pass orders in his absence.
Yes, sir. Obliged.
Item 4.
Item 4. Yes. There's a lot of articles.
These matters, civil matters.
Yes.
If this matter, item 4 can be taken up on Thursday, I'll inform the council for the respondent number 7.
Thursday?
Yes, if time permitting.
Which, both 4 and 5 or only 4?
Item 5 and 6 may come up after the vacation, Your Worship.
Okay, item number 4 he is praying for?
If possible, time permitting on Thursday.
On Thursday. And 5 and 6 you want after the vacations?
Yes.
On a request made by, you are appealing for the appellants?
In item 5, I am for the appellant.
Okay.
In item 6, I am for the respondent.
In item 5, you write down on a request made by the Learned Counsel for the appellant. Place this matter in the hearing list immediately after the vacations, puja vacations. And in the item number 6, put down there at the request of the Learned Counsel for the
respondent number 1 and 2.
Respondent number 1 and 2 with the consent of the counsel for the appellants. You have informed him, I hope?
Yes, I'll inform.
So what about 7? I don't know, just make a call so that everybody knows, bar knows that we will call up the matters. Anybody present, we can do it.
Item 8 also, this can come up after the vacation then, Your Worship.
Same order as item number 5.
Item 7.
Item 7, anybody appearing? Nobody. Tomorrow. Item 8 has just been...
Item 9.
9.
I'm appearing on behalf of my senior Mr. Bilaram Ema. And my lord, if the matter be passed over for today and taken up on Thursday.
Pass over for today?
Yes, my lord.
To call upon when? When do you want
Thursday,
it?
my lord. If possible.
Thursday. Okay, Thursday. Item 9, Thursday.
Item 12.
Thank you.